Welcome to the Capital Forum interview series sponsored by Kroll Discovery. I'm Sally Hubbard, and I have here with me today Kathleen Foote. She heads up antitrust enforcement for the state of California. She's the Senior Assistant Attorney General of the Department of Justice there. Kathleen, thank you so much for joining me today.
It's a pleasure to be here.
So one question that is on everyone's minds is what role can the states play if federal enforcement becomes lax or less aggressive than usual?
Well, that is certainly seems to be a question that I hear being asked very often. Let me just begin by saying that federal enforcement is enormously important, particularly now when competition seems to be reduced. And enforcement is all the more important. If federal enforcement does, for some reason, become anemic, it's going to be a huge loss to consumers, to entrepreneurs, to all of us, really. And a great pity given the numbers of wonderful professionals that have been doing antitrust enforcement for the Justice Department and the Federal Trade Commission for all these many years. That is most certainly what I think everyone feels. Moving on for the states, and let me just say, obviously, these are my own thoughts and not the official position. I'm not speaking for my Attorney General or any other for that matter. We have the states, interestingly enough, became involved in antitrust enforcement really during the 1980s, during the Reagan era, when federal enforcement, certainly federal civil enforcement, backed off. And there were not all states, but a number of states became interested in filling some of that space, and did, and ultimately it grew, and our role became a significant one in antitrust enforcement. By no means the most significant, but an important one, and one that continues to grow, I think, as we develop collectively and individually as enforcement units. And whatever happens in this new era, I think our growth is going to continue and is going to be affected to some degree by what happens with other enforcers. But that said, there's really two different aspects of what happens. One aspect has to do with staffing, and the other aspect has to do with case selection. With regard to staffing, that is where I think that is where I see the problem that I am anticipating at the federal level, simply because there seem to be indications of budgetary cutbacks. And although I don't know for certain that there are in this area, there certainly are in other areas that look to me to have play similar roles. And that is something that certainly invites the states to step, not to step into new roles so much as to step into larger roles of the ones we're already playing. We have over the years developed some very good working relationships, and increasingly I think the states have demonstrated to the federal enforcers that we are good partners. We are trained, we're reliable, we have some resources, and we operate along the same agenda. Truthfully, that agenda is not particularly a political agenda. There's a kind of bipartisan agreement that's developed over the years that facts and economic data play a very large role. And so I don't anticipate any real change in our ability to work together. I do see potentially the states playing a larger role in the investigative process. in deposition taking and in document work. We are finally making some considerable progress on developing smooth e-discovery coordination. For a long time, we didn't, because every different organization had its own security system. But we have now got things, a lot of the kinks worked out of that system. With regard to case selection, is another, I would say, an edgier question. Case selection does depend in part on kind of enforcement philosophy, and it depends in part on different perceptions of the needs. For the states, each state is its own enforcement agency, and each state makes its own case selection decisions. There are now some areas where it's pretty clear that the states have ongoing concerns collectively. One of those is healthcare. Every time the state group has gotten itself together, when there's perhaps 40 states in the room, it usually turns out that 2/3 to 3/4 of us have healthcare matters that we're investigating within our own states. I don't see that changing. It does mean that is an area where we have good expertise and pretty good connections. We've worked with economists. We've in some cases gone to trial, and all of that makes us all the readier to move more strongly in that area than we have in the past. That's not a real shift in priorities, but it is something where I think it's not unreasonable to expect most states to step up to the plate should there be any gap that needs to be filled.
Yeah, I was gonna say one thing that you said at the beginning that I thought was really interesting is you said now is a very important time to have the resources toward federal and state enforcement because of concentration being greater.
Mm-hmm.
So is it in your view that concentration in our economy has gotten more concentrated and that now is actually a very important time for antitrust enforcement?
It is extremely important. Concentration, certainly in a number of industries, has been documented. And there are a number of sectors, even at this antitrust conference, you hear more and more talk about the fact that there are various sectors where there is concentration is too great. There have been price increases as a result, and also that there are some sophisticated markets where essentially the free market system is not working. Healthcare is one of those. It's obviously complicated. It's one of those two-sided markets. When I say healthcare, there are different aspects of healthcare relating to provider healthcare, but also insurer healthcare, and pharmacy benefit management phenomena as well. With a lot of unclear roles, uncertainty where there's a fiduciary relationship and where there isn't, and consumers that find it extremely difficult to wade through the system in order to find the most cost-effective thing to buy.
Right.
Very definitely the case.
And drug pricing is a majorly hot topic right now. And I know some of the states are even passing, anti-price gouging laws to try to address drug pricing. So, what role do you think that state enforcement can play on drug pricing issues?
I think the states. That's another area where the states are going to play a significant role. Are already playing a significant role for quite a number of years now. The states have been working closely with the Federal Trade Commission on reverse payments agreements by pharmaceutical manufacturers. We have a task force within NAG, the National Association of Attorneys General, looking at pharmacy at the pharmaceutical industry, and it falls right into an area where states are directly heavily impacted because state government is an enormous purchaser of pharmaceuticals, both directly because of the various state agencies, the state responsibilities. Think for a moment about the California prison system, and indirectly because the states are the entities that deal with Medicare and Medicaid programs.
Right. So it's a very state-specific issue.
Very state-specific issue.
Now, with some of the national mergers that don't necessarily affect one state heavily, do you see the states getting involved in the bigger national mergers if you find that, enforcement at the federal level has gone down drastically?
That's an area that I think is going to differ a great deal from one state to the next. And the state attorney general is the one, of course, that is going to make the ultimate decision to get involved or not involved. I would say that the national mergers are not an easy area for us, although many national mergers, if you look, for example, at Anthem Cigna and Aetna Humana, and states were involved in both of those. Those are national mergers. There was a national market, and then there are also local markets that were an important part of the case. You can do a case just based on the local markets and prevail. And I think in a situation like that, where there are clear local markets within a national context, it would be interesting for several states to band together and then have to decide what court to file in. If we're with the Justice Department or the Federal Trade Commission, we're obviously most likely in D.C. And exactly how we would decide whose court to file in would be an interesting discussion, and possibly one we will find ourselves having. But the areas where there are certainly areas where we have done our own merger enforcement, or where our local interests have played a very strong role, even when there is a federal presence. Those are the ones that I would say unquestionably the states would move forward. Where there are state regulatory interests, such as waste hauling, where there's state purchaser interests, or where there are just local markets. I mean, the states are walking databases about supermarkets, for example. I would say we are also walking databases about gas stations and refineries. So those are ones where we would very likely, almost certainly, step forward. We certainly would be resource challenged in doing that. We are, most of us, staffed based on an assumption that there will be and continue to be vigorous federal enforcement. And again, it's important I think, certainly in the interest of the country at large, as well as our interest, that continue to be the case. With regard to those that are sort of more federal, if you will, in nature, that remains a question, and I think some states are really going to stay out of that, and other states may not. And again, how federal is federal? I mean, if we're talking about the National Aerospace Program as being the one with the greatest impact, I don't really see that states are going to be eager to step forward into that space. There are other areas where, I mean, even in something like telecom, which is certainly very federal in terms of federal regulation, there are important state interests. There are state commissions, public utility commissions that have an interest and may even have some regulatory role to play. And there are local markets that are very identifiably affected. So on a case-by-case basis, we're going to have to go forward, and the extent to which our staffing levels need to change, that will be a process that will we will need to deal with within each state. There are certainly states already attempting to tackle that, not just with regard to antitrust, but other areas that look to be impacted by the new approach, what my New York colleague this morning referred to as the new mercantilism in Washington. And there are certainly efforts to get legislative support for additional staff and so on. And I think antitrust ought to be on that list, along with environment, immigration, and issues of that kind. But we obviously will be, to some extent, competing with those areas for the additional staffing that our attorneys general want to get and need to get.
Right. There's a lot of need.
There's a lot of need. That's right. Yeah.
Well, thank you so much for being here. It's been such a pleasure talking to you, and thanks for your service for California. Looking forward to California's continued leadership with among the state's attorneys general.
Well, we hope to be doing our best for quite some time to come. Thank you. Okay. Bye-bye.